Okay, well, good morning, everyone, and thank you for joining our webinar, Parker-Jewish Institute. My name is Dawn Hagan. I'm the Program Director for the Caregiver Support Initiative here at Parker-Jewish Institute. And we have the honor of having Mr. Eric Einhart, who is an elder law attorney from Vincent J. Russo Law Group, and he's going to do a presentation on guardianship, decision-making for those who lack capacity. This is a general overview of guardianship. Just would like to introduce Mr. Einhart, who is a partner with Russo Law Group. He practices in the area of guardianship, elder law, estate planning, special needs planning, trust and estate administration, tax law, and real estate. Here is pretty much a little bit about more about Mr. Einhart. You can see for yourself. In the essence of time, we do have a lot to cover, and I want to make sure that Eric can get through all of the material and through the slides. We do have the slides available on PDF. I think your office sent that to us earlier today or yesterday. So we do have that available. If you do have questions, please put them into the chat box, and we will try to get through them toward the end of the presentation. Just in the sake of making sure that we can cover all the material, we will hold off on the questions and answers to the end. I will be putting up a general an email address for if you do have questions after the webinar is finished, and it's not answered, you can actually send your questions to the general email. So without further ado, I'm going to mute myself, and I'm going to let Eric take over. And thank you very much for joining us.
Thank you so much, Dawn. It's a pleasure to be here with everybody virtually, but here. I wanted to just right off the bat just let you all know that this is for general purposes, this presentation, and nothing that I'm saying today should really be construed as legal advice. So with that said, what are we going to cover today? We're going to talk about how decisions are made for individuals who need help, who has the right to make decisions for you, how are financial decisions made, how are healthcare decisions made, and generally the process for guardianships to become a guardian, and what do you do once you are a guardian? Okay, so for the first two, I can really kind of just touch base on them now. How are decisions made for an individual who needs help? Well, first off, if the individual needs help and they have the ability to make decisions in some capacity, they're the shot caller. They're the one that's going to make the decision, and you might be able to help them execute that decision. But if they are able to provide any kind of input, but just have some difficulty, then you're going to be listening to them as much as you can. But if the person does not have capacity to make a decision, to understand the decision, or to communicate their decision, then you're going to need someone to step in their shoes, whether it's an agent under a power of attorney, a healthcare proxy, or a guardian. So the question, who has the right to make a decision for you? Again, if you have capacity, you're the only person that should be making these decisions for yourself, unless you lack capacity or you need assistance, and someone's going to be executing those decisions for you. So we try to promote autonomy as much as possible, but I do realize and recognize that there are situations where there's an inability to understand or effectuate your decision. So that's why we have these legal mechanisms in place to allow someone else to step in and help out. Right. So talking about finances, how will your finances be taken care of if you lack capacity? So hopefully you've executed a durable power of attorney if you had capacity. So if you have never had capacity, then you are not able to execute a durable power of attorney. But if you once had capacity, legal capacity, you would execute a durable power of attorney, and this document would allow financial decisions to be made by an agent, and they can manage your assets, income, and legal affairs. And a power of attorney, there's a couple of different types of power of attorney. What I'm really referring to here is a comprehensive durable power of attorney. You may have heard of springing powers of attorney or just general powers of attorney. Those are not as helpful in my opinion. I think that what we generally suggest is a comprehensive durable power of attorney. And if you have a power of attorney or you're thinking of executing power of attorney, I would want my clients to have the latest and the greatest durable power of attorney. There's a couple different forms, and we want to make sure that you have the most updated form, and it's executed properly. And the authorities that you grant to your agent is comprehensive. So you have a statutory short form. It's within the law. There's a framework of what must be in a power of attorney, a durable power of attorney. And if you do not have at least the framework, you could expand upon it and modify it in some regard, but you have to have the framework. So it's a statutory power of attorney. In this document, you are the principal and you are appointing an agent or co-agents to manage your finances, manage your legal affairs. They can essentially, depending on the powers that you've granted them, they could do anything that you could do, with some exceptions, like, decide where to live or to get divorced. So the agents can act together, or you can allow them to act separately if you've elected co-agents, or you could have kind of a hierarchy, one at a time. And if there's the initial agent is able to act and is willing to act, that person will continue to act until you've either terminated the durable power of attorney, or you've passed, or they've passed, and then the successor would step in. The agent has a fiduciary obligation to follow your instructions, or if you're not capable of providing instructions, to act in your best interest. So it's a fiduciary obligation, and it's a serious role, and they can be held liable if they don't honor those roles or those obligations. If you're concerned about your agent, you could always appoint a monitor, which is kind of a third party that could monitor the actions of the agents. My general sense is, if you're concerned about your agent, you probably shouldn't name that person as agent. But sometimes you're in a situation where you have to have professionals act for you, or your options are limited, and you may want someone to kind of be a little bit of a watchdog. So you could appoint a monitor. The agents must be competent adults. That usually raises a little bit of eyebrows for my clients, and they say, well, my son's kind of an idiot, but yeah, I guess he's a competent adult. But we mean someone who has the legal capacity to act as an agent and must be at least over the age of 18. So you should trust them, and you should think that they're capable of doing it. But the bare minimum is they have to be 18 years old and have capacity. Compensation could be allowed for the agent if you'd like that. But a lot of times in family situations, they won't have compensation. I generally suggest to allow the compensation provision. This way the agent can waive it if necessary. And sometimes there's a strategic reason why you would want them to take compensation for their services. And it's limited in terms of what they can take. It's a reasonable compensation, which is defined by case law. There is gifting provisions that could be included in your durable power of attorney. And we generally suggest that you authorize gifting provisions unless there's a specific reason why you do not. And this is not necessarily to be, so the agent could be, generous with your money. It's really for strategic purposes. So for instance, if you need to do Medicaid planning or tax planning, this would allow the agent to gift your resources in a strategic way to help, achieve a goal that is necessary. If you have an agent that is also a child or a person that you would want to receive the gift or hold on to the money, they're prohibited from self-dealing unless you've explicitly authorized them to self-deal and transfer resources to themselves. So that's important to be aware of, because you don't want to sign a power of attorney with the expectation that, okay, this is my son or my daughter, and they're going to be able to transfer money to themselves, holding on to it for me. And then if they don't have that authority, then they're prohibited from doing that. So you want to be aware of that. So as I mentioned, durable power of attorney can be limited. You could provide limited authorities, maybe just, okay, I want them to just handle my real estate transaction because I'm going out of town and I need somebody to handle a closing for me. Or it could be much more expansive, and it could be for the what ifs and the unknowns of the future. And we generally suggest to make your durable power of attorney as comprehensive as possible if we're doing this for estate planning or long-term care planning needs. But if it's for a specific action and you only want this agent to act for 1 or 2 transactions, then you want to limit their authority. Okay. So what can they do as your agent under your power of attorney? They can manage your assets and your income. They can handle your banking transactions. They can buy and sell stocks and bonds, manage your brokerage assets, your real estate, whether it's buying and selling real estate or handling property tax payments. They can access your digital assets if you have Bitcoin or points on Amex or something like that. They can also manage your retirement funds and handle your income taxes if necessary. They also can stand in your shoes in the event that there is a lawsuit that's necessary, whether you're a defendant of a lawsuit or you need to, or you want to be a plaintiff of a lawsuit, or something happened to you that caused you to lack capacity. This agent under your power of attorney can handle that legal action in your stead. Okay, so enough about finances. Who has the right to make a healthcare decision? So the answer is you. You have the right to make your own decisions, and no one really should be making a decision for you unless you're not able to understand or communicate your decisions. And if that's the case, if you have a healthcare proxy, which is a legal document that allows you as the principal to designate a healthcare proxy to make a decision on your behalf. This is not somebody that is making a decision that they feel is a good one for you. It's something that they're supposed to be acting as your surrogate. So hopefully you've communicated with them different types of treatments that you would or would not like to have in certain situations. This way they can just make a decision that is really carrying out your known wishes. In this case, you cannot have more than one agent acting at a time. So we don't want to have 2 different healthcare proxies with 2 different opinions about your healthcare needs being deadlocked and not able to get anything done. So under the law, you can only have one agent acting at a time, but you could have successor agents in the event that your initial agent is not able to act or is unwilling to act, or they're just not available for some reason. The healthcare proxy document also indicates your wishes as to organ donation upon your passing. And this is something that we generally have no input on in terms of decisions. It's completely up to the client, but it is included in that document. And if you wanted to be an organ donor, this would be the place where you could indicate it. It also has a provision that relates to your artificial nutrition and hydration wishes. Although this is not a living will and it should not be used in place of a living will, this does indicate your artificial nutrition and hydration wishes. What's important here is that even if you have a healthcare proxy, you're still making the decisions. It's just if you lack the capacity, the healthcare proxy can step in. And that's a pretty important distinction between the power of attorney and the healthcare proxy. Power of attorney can make a decision now if you have capacity or if you lack it in the future. So if you're laid up in a hospital and you still can make decisions for yourself, but you need someone to go handle your banking needs, the durable power of attorney can step in and make that decision. But if you're in the hospital and you can make decisions for yourself, the healthcare proxy really has no right to be making a decision for you. So they're only stepping in the event that you lack the capacity to understand or communicate your decisions. So, they're just the peanut gallery until you actually need them to step into that role. So the question then becomes, who has the right to make life-sustaining treatment decisions, which is, just kind of use a colloquial term, life support. Who has the right to make that determination whether you are or not on life support? Well, again, the answer is that you have that right, so long as you have the understanding of the decision and can communicate that decision. If you do not have that ability, then what I would suggest, if you do not want to remain on life support and have extraordinary life-sustaining treatment under certain circumstances, you should have a living will. This is a document that's constantly confused with the last will and testament. I think it's just because of the name will in it, but this is a document that evidences your wishes with regard to extraordinary life-sustaining treatment. So this document will evidence your wishes, and the triggering events here would be if you are, upon the concurrence of 2 doctors, if you're in a persistent vegetative state and in a terminal setting, then this will authorize the facility or the healthcare provider to withhold or withdraw extraordinary life-sustaining treatment. It's also intended to reflect your beliefs, and with regards to mention your pain relief medication, and it has no appointment of an individual. It's purely just a piece of evidence that allows the life support to be removed or withheld. So what happens if you don't have these advanced directives, the durable power of attorney, the healthcare proxy, and the living will? Well, no one has the right to make a legal, financial, or personal decision for you without court intervention. So you're going to have court intervention. You have to have a guardian appointed. So our goal in talking to clients while they have the capacity is to run, not walk, to have the advanced directives done, because this is an opportunity to make sure that the people that you want to make a decision for you will have a really good shot at making that decision for you, and there's not going to be a court intervention and someone else making a decision as to who is in charge of making financial and personal decisions. So it's really important to have a durable power of attorney, a healthcare proxy, a HIPAA authorization, and a living will if you want one, and we also include a barrel designation, which we're not going to get into here, but advanced directives are important because you don't want to have the court come in and make a decision about who has that right to make decisions for you. So if you don't have advanced directives, before you get to a situation where you're in court, there is a Healthcare Decision-Making Act that allows kind of a default of a healthcare surrogate in certain settings. So for instance, if you're in a hospital and you lack the ability to make a decision or understand a decision, there is a default hierarchy where the hospital could then designate or identify a surrogate that can make a decision on your behalf. This is by no means a permanent solution, and by no means the best case scenario, because the hierarchy that is stated in the statute may not be the same hierarchy of the people that you would want to be making these decisions. So it starts off at the top with a guardian appointed under our mental hygiene law, Article 81. The guardian trumps everybody. A spouse, if you're not legally separated, or a domestic partner. So they're number 2 in that list, and they can make a decision regarding your health care. If you have an adult child, then your adult child can make that decision. I mean, adult is an 18-year-old. I don't know that I would want to trust an 18-year-old with my medical decisions, but it's certainly in the statute and legal. If you do not have any adult children, then your parents, and then it goes to siblings, as long as they're 18 years old or older, and then a close friend, which is, to me, very nebulous. I mean, I don't know that I trust any of my friends to make that kind of decision. So if you don't have a healthcare proxy and you're in this situation, then you can rely upon the statute, but it may not be a comfortable reliance. And we certainly wouldn't suggest using this as your go-to authorization. All right, so what does the surrogate have the ability to do? They can access your medical information and records necessary to make the decision. So you need the good information in order to make the good decision, and the surrogate can access that information in order to make the judgment call on your behalf. They can cease, their authority stops once the physician determines that you're no longer in need of a surrogate. So if you kind of come out of it, essentially, they're done. There's no more decision making for them with regard to your health care. And they have to make a decision based off of your known wishes. But a lot of times when you're in a situation where it's an emergency, or the person who needs your help never really communicated what their wishes were. So essentially, if they didn't get their ducks in a row or communicate this with somebody, you're going to be just kind of guessing based off their personality and any prior conversations you had. So it's really going to be looking at their religious beliefs, their personal beliefs, and any best interests that you can think of for them. So it's tough judgment call by the surrogate. But that's why you really should be planning ahead of time. So if you're looking for a more permanent solution, if someone lacks capacity and they do not have advanced directives like a durable power of attorney, healthcare proxy, and living will, then you're going to be pursuing a guardianship proceeding. And by the way, not having advanced directives is not a moral failure. It happens to a lot of people, and it's just, you don't get around to it, or maybe they never had the capacity to execute those documents to begin with. So court guardianship proceedings, although I would like to try to help my clients avoid them, they are a necessity in a lot of situations, and it's something that it really can provide a lot of benefit to the individual and their family. It's just, if you could try to avoid it, I would do so. So there's 3 different types of guardianship proceedings in New York State. We have the Mental Hygiene Law Article 81 guardianship, which is a guardianship for someone who once had capacity and now has functional limitations to the extent where they need assistance, or they may not have the capacity to handle their own affairs, so someone needs to step in as a guardian. And this guardianship proceeding, you could bifurcate the authority. So you could have a guardian of the personal needs, personal management, and the property management. Sometimes it's the same person, sometimes it's 2 different people with 2 different skill sets, but they split up essentially the powers. And this is a much more tailor fit and independent-minded guardianship than the 17A and the 17, which are typically plenary. So you have the Mental Hygiene Law Article 81 guardianship, and then you have the Surrogates Court Guardianship 17A, Surrogates Court Procedure Act Article 17A guardianship, which is for adults with developmental disabilities, intellectual disabilities, or traumatic brain injury. And this is a guardianship that's in the surrogates court. And again, you can have a guardian of the person or a guardian of the property, or both. And they could be 2 different people, they could be the same person. This is not tailor fit. It is kind of an all or nothing situation. So you're either the guardian of all of that person's personal needs, or you're the guardian of all their property management needs, or nothing. So it is kind of an all or nothing situation. And sometimes you'll have a situation where you may have an individual that would qualify for a 17A guardianship medically. It's based off of medical evidence. They're intellectually disabled or developmentally disabled. But perhaps the Article 81 proceeding provides more flexibility for that person's lifestyle and wishes, and that may be a more appropriate guardianship proceeding. It's more onerous to get, but it does provide more flexibility. So, there's really no one size fits all for any one individual, and we really want to take a look at the person, the search circumstances, and figure out which is the best guardianship, whether it's an 81 or a 17A. The Article 17 proceeding is for a minor. This is for someone under the age of 18. And this could be a guardian of their person, or this could be a guardian of their property. And typically what we see in situations like this is typically a grandparent or a relative with best of intentions had left money as to a minor, either named them as a beneficiary designation or left them in money in their will, but didn't provide a minor's trust. So until they reach 18, you need someone appointed to manage that property. And in New York State, if it's $10,000 or more, you're going to need to have a Surrogates Court Procedure Act Article 17 guardian appointed for that minor, so they can help them make decisions. If the minor does not have any parents that are alive, the natural guardians, then you could have a guardian of the personal needs. And that does occur every so often, but in our practice, we typically see a guardian of the property as more common than guardian of the person for a minor. So I'm going to focus today's talk about Article 81 guardianships. And just to kind of give you a sense of the difference, in the name of the 17A and the 17 guardianships, it's the Surrogates Court Procedure Act, Article 17A, Surrogates Court Procedure Act, Article 17. So that is handled in the surrogates court. And typically in New York State, there's only one surrogate per county. I think Brooklyn and Manhattan are a little bit little bit different, but generally speaking, you have one judge and one court running that process or reviewing that process. The Mental Hygiene Law, Article 81, guardianship, it is the Supreme Court, and there are a number of different judges. However, there typically is in each county, there's like one or two judges that handle a lot of them, so they develop an expertise in them. All the judges know what they're doing, and they're great at what they do. However, they may not have the same experience with Article 81. So I think, to me, that's important as a practitioner for the Supreme Court, because you may get a different judge that doesn't have the same experience level, and you may need to educate them a bit with regard to the proceeding itself and also the needs of the individuals, whether it's we're talking about Medicaid planning or end of life care wishes. So there's some nuances that the practitioner needs to be able to communicate effectively and educate the court in a way that's not going to overstep their role. So it's in the Supreme Court. It's adults with functional limitations. This is someone who once had capacity, but maybe has lost capacity in some regard. And it is regarding to the person and or the property. And what's very important here is that it's not based on medical evidence. So this is a common misconception. All right, well, my mom or my dad was diagnosed with Alzheimer's or dementia. They really need a guardianship. Well, guess what? That diagnosis is not going to be entered into the evidence, and it's not going to be taken into effect into consideration unless they present it to the court to say, hey, listen, look at my medical evidence. I don't need a guardian. Then that opens the door for you at providing medical evidence into the court. But generally speaking, on a practical, real world experience, that doesn't really happen. So you really cannot base off of medical evidence. It has to be based off of your experience or your observations of their functional limitations. So, my dad provides his credit card information to anybody who asks. He's constantly being scammed, or he's fallen a number of times and refuses assistance or doesn't understand where he is. So you have to base off of the observations that would lead a judge to be comfortable and understand that they don't understand how to manage their affairs, and they don't understand the harm that lack of understanding is actually coming to fruition. So it's not based on medical evidence, based on personal observation. It's least restrictive means, which again is I think a blessing in a lot of cases, because you could have someone who really does have the ability to make some decisions for themselves and can handle some things, but they just need help with other things. So for instance, my grandmother may be able to make a decision about her healthcare needs, but she's really not capable of handling her finances anymore, and she needs somebody to assist her with that. So you can kind of tailor fit the needs of the person and allow them to have some autonomy and some decision making in their lives, which I think is a good thing. Sometimes it could be tricky because they'll eventually lose that capacity, and you're going to need to go back into court to have the authorities or the powers expanded. But I think it's good for the individual because they have a sense of themselves and they still have that autonomy. You're not taking over their life as a guardian, which can be scary for them. So the process to obtain a mental hygiene law Article 81 guardianship, it could be onerous and it could be expensive. And quite honestly, it could be emotionally draining for the family and for the individual, because you're essentially telling the court what's wrong with somebody that you've known for a long time and have come to love and understand as a person who has capacity. Now you're saying they've lost capacity, you're trying to take control in some way. So it can be very challenging, and there is hearings that are involved. If there's objections, there could be litigation. So it could be a process. In terms of the actual mechanics of the process, you're essentially filing a petition. If you're the petitioner, asking for the guardianship, explaining the circumstances, who the person is you want guardianship over, what their deficiencies or the lack of their functional limitations are, what powers you're asking, and you're explaining who their people are, who's their next of kin, who are important people in their lives, if they're in a facility, who's in charge of the facility, and you're giving the court this information. The court's then going to appoint a court evaluator, which is a person that doesn't necessarily work for the court system, but they're appointed by the judge to go out into the community and be the eyes and the ears for the court. So they're going to interview, they're going to meet with the alleged incapacitated person, the person that's, the guardianship is for. They're going to explain their rights to this person and ask them questions. They're going to meet with the petitioner. They're going to meet with family members, anybody who's relevant in this person's life, and they're going to review financial records, and they could access medical records. Although it's not entered into evidence, it's a part of their report and the flavor of the circumstances that they're going to explain to the court. And they will provide a written report to the court. You may or may not ever get a copy of that written report. It may be kept in camera in the judge's eyes only, essentially. And they're going to provide testimony at the hearing about their observations and their suggestions in how the proceeding, which way the proceeding goes. The court could appoint an attorney for the alleged incapacitated person. That's the person you're pursuing guardianship over. Or that person, if they have the ability to do this, they can obtain their own counsel and they could object to the proceeding. Or the flip opposite, they can recognize the limitations that they have and they can consent to a guardianship, and they would be what's known as a person in need of a guardian rather than an incapacitated person. So it's basically a guardianship on consent, which can be a really good solution if they're willing to accept it, the help, and if they need it. And you will be providing testimony at the hearing. So it's the petition, it's the evaluation by the court evaluator, and it's a hearing. It's testimony explaining your observations to prove that this person needs a guardian. So the process, first thing you should do is obtain legal counsel. If you're looking to be a guardian over someone, and especially in a mental hygiene law Article 81 guardianship proceeding, you absolutely should have appropriate legal counsel to help you through the process. It is litigation inherently, so you really need a professional who knows what they're doing. You're going to petition the court. You're going to determine, the court's going to determine ultimately what authorities you have and who is appointed as the guardian. So even if you're petitioning and you're saying, Your Honor, I think I'm the best person for the job, depending on the outcome of the hearing, if someone's objecting or if they have something that they raise as a question in your past, you may not be appointed as the guardian. That doesn't necessarily mean you're not successful. It just means that someone else is going to be in that role, and you've done your job to get somebody to look out for your loved one or the person who needs a guardian. So obtain legal counsel. They're going to petition the court, and the court's going to make a decision about whether this person needs a guardian or not, and what powers to have. So what are the benefits of a guardianship? They are many. So if you need a guardian, and if there is someone who lacks capacity, they can handle all kinds of things for the person. They can essentially step into that person's shoes and make decisions for them with regard to a wide array of topics. So depending on what powers the court grants, they can protect the assets from loss. They can do Medicaid planning. They can do estate or tax planning. They can apply for government benefits like Medicaid or SSI. They can institute a special needs trust. They can handle investment property, or make sure that their property is invested prudently, because sometimes you have people who just have $500,000 in a checking account or a savings account, which seems kind of nuts to me, but then they may have a reason for it. And if they need that money to grow and use to live off of, you can, as the guardian, invest it prudently for them. And you can access money to make expenditures for them. So a lot of times people who need a guardian will have a lot of bills piled up because they just haven't had the capacity to manage their money and manage their bills appropriately. And once you're appointed guardian, you can step in, access to the money, and make payments like property taxes or care costs, things like that. On the personal side, you're also able to make decisions with regard to their health care. You're able to make decisions about their social environment. So if there is somebody who's targeting them for abuse or something, you can make the decision that that person is no longer in their life, or they have to go through you in order to access them at all. And you can kind of be the gatekeeper in that regard. You can make a decision with regard to their living arrangements. and end of life care. You could also make a determination about where they should live and whether they should move from where they're currently living. Generally, that would require a further court approval, just because the court wants to make sure you're not moving the person inappropriately or out of state lines or something, because that would impact the jurisdiction the court has over the individual. So you can do all these things, but sometimes there's going to be a check-in with the court, and the court gets the final approval of whether you can or you cannot do a certain action. So they'll say you can do Medicaid planning subject to court approval, or you can change the abode of the individual subject to court approval. And then that means the court knows that it's an understood thing that this may happen, but you just need to check in with them and get them to specifically authorize that power when you're going to execute it. So to get to be a guardian can be time consuming and challenging and emotionally draining and expensive. But now that you're the guardian in this situation, this hypothetical, what do? It's not a cakewalk at that point. There is still a lot of things you need to, your obligations to the court don't just end at your appointment. It actually begins at that point, and you have to file an initial report within 90 days of being commissioned. So the process, mechanics is that the court you'll have the hearing, you'll be successful, as you say. The court issues an order in judgment that outlines your exact authorities and the exact obligations that you have to the court. And that order in judgment is very important to review. And you should have counsel, and your counsel should review it very carefully with you and explain, paragraph by paragraph, what this means, what this means for your obligations in the future. And so that's like kind of the go-to rules for you being the guardian. It's kind of the foundations, the 10 commandments, essentially, of being a guardian. So you're going to review the order in judgment. You're going to get commissioned, which is really just providing a certified copy to the county clerk's office and making sure that you're officially the guardian. It's not enough to have the order in judgment. You need to be commissioned. And then there's an initial report where you have to provide, basically it's a check-in within the first 90 days of your being appointed as the guardian. I like to think of it as like a probation period, essentially. So during that 90 days, you're going to meet with the individual. You're going to have guardianship training and be certified as a guardian. It's about 6 hours you can either do it in person or online. But it is important for you to learn about the ins and the outs of the guardianship and what your responsibilities are. Even if you have counsel who's helping you, you will need to get guardianship training, typically, unless the court waives it, which they don't usually. And then you need to check in with the court to let them know what you've done and the obligations that you've met during the first 90 days of your guardianship. Then you're going to need to report and account for your actions annually. If you're the guardian of the property, this means an accounting that you have to compile and submit by May 15th of the following year. So for 2022, your accounting is due May 15th, 2023, and it has to indicate all the assets that you've collected in the guardianship, all the income that you've received, all the expenditures you've made, and any investments that have been made as well. So it's really, what have you done in the past year? If you're the guardian of the property, then you're going to need to account for any medical updates that are necessary. If the person is moved or in a care facility and now in a different part of the care facility, you should provide that information. And there is a gatekeeper for all this, and it's not the court evaluator. That person's job is done once the guardianship is put into place. There becomes another role that another person comes in and does, and it's the court examiner. And the court examiner is, again, not an employee of the court, but they're appointed by the judge, usually a lawyer or a CPA, that will review your accountings and submit reports based off of those accountings, essentially checking the numbers and checking the information and submitting the report to the court saying, this one looks good, and the judge will review the report and review the annual account that you've provided and the court examiner's report, and hopefully issue an order approving it annually. So it's time consuming and it's onerous, but the court examiner, typically they're good at what they do, and that you'll be able to talk with them and get some input as to whether this accounting looks good, or if there's any changes they want to be made. You can rely on them. Or if you have counsel, legal counsel, your legal counsel could help you along the way with your accounting and prepare it for you, actually. You just need to sign off on it. Another thing that you need to be mindful of is special requests. So for instance, let's say you want, the individual, the incapacitated person, to move from their current residence to another residence, and you need to go back to the court to ask for their permission. You're going to need to file a petition or a motion with the court at that point and ask them to approve something. So you're going to have to ask for certain things potentially. There's another opportunity for you to have an interaction with the court. That's when either you resign as the guardian or you pass away. Obviously, you're not going to be doing anything if you pass away as the guardian. It's going to be the successor that steps into the role. But if you're looking to resign or step back or have someone else put in place or a co-guardian put in place, because it's a lot of work, that's when you would, request the court, provide that you resign. You can't just say, I'm done with this. There's a formal process for your resignation. If the guardianship needs to be terminated, let's say miraculously the person now doesn't need a guardian anymore and they have capacity themselves, either they can petition the court to terminate the guardianship or you can petition the court to terminate the guardianship. I have not seen that happen yet in the past 10 years, but I know it's possible. I've heard stories. Typically, the termination of the guardianship that I see, unfortunately, is that the incapacitated person passes away, and there are certain requirements that you have as guardian to inform the court, inform family members or next of kin, and then you have to provide a final report and account and get the court to issue an order to terminate you or release you as the guardian. So it's not just the person passes away and you're done as a guardian. There's a process that has to occur after the fact, and that could take months or a year depending on what is left to do. So it's a labor of love, and it's not something that I think that I would want my clients to have this situation, but if they do, there is this guardianship process is going to be necessary and helpful. Okay, so when you're the guardian, there's certain things that you may need to handle for your incapacitated person, like Medicaid planning. Oftentimes, when there's a need for a guardianship, there's also a need for Medicaid because there's a lack of functional limitations, and there's maybe some long-term care issues that are at place. So you're going to need to, either at the onset of the guardianship or at some point during the guardianship, you may need to ask the court for the authority to do Medicaid planning. And the way that I like to think about it is, first, you're going to determine the need for long-term care planning. So what long-term care services does your incapacitated person need? You're going to meet with a qualified elder law attorney that could establish a Medicaid plan based off those needs. They're going to petition the court to explain the needs of the person, explain the plan, and explain the legal support why the plan should be approved by the court. Oftentimes, if you have a judge who's not really familiar with Medicaid planning, then they're going to say, wait a second, so you want to transfer this person's property from them to their spouse, or from them to their child, or from them to a Medicaid asset protection trust? Whoa, hold the phone here. The attorney should be able to educate the legal support for that decision and the reason why the judge should approve it. So once you do that, and I usually provide a very long, very detailed, very carefully drawn out legal memorandum for the court, for the opposing counsel, if there is any, and for any court examiner, so that they can see very clearly what we're looking to do and why it's in the best interest of this person. So Medicaid planning comes up often in guardianship, and you really need to work with somebody who's well-versed in not only Medicaid planning, but the guardianship world as well. So you need kind of have a foot in both those worlds. So there's also potential in this mobile world that we live in, where a guardianship would be transferred from one state to another. Oftentimes we'll see people who lose capacity in Florida or Pennsylvania or something where they've retired to, and then they need to move back to New York to be with family who could help them. And that family, who may be appointed as guardian in the other jurisdiction, needs to transfer the guardianship from that jurisdiction to New York. There is not a national federal statute that authorizes guardianships to be moved from one state to the next. It's kind of a patchwork of statutes and legal authorities, and it doesn't extend to beyond each state. There's no full faith and credit for guardianships in the United States. So the next best thing is there's uniform guardianship procedures where you can transfer in a more streamlined way the guardianship from one state to another. And this is absolutely possible. I've done a bunch of them, but it's not as quick and not as seamless as you would hope. It is still a legal proceeding, but you don't necessarily have to have the person determined and incapacitated in each state. Once they're determined incapacitated in one state, there is a process to transition it to another in and out of New York. So also another common thing that occurs after a guardianship is guardian is appointed is there may be a need to sell real property. So if your incapacitated person owns real property, lost capacity, is now in a residential care facility, then what do you do with that property? If no one's living in it, it might just be kind of an albatross and an expense that eats into their resources every month, or it could be their only resource that's going to be used to cover the cost of the care of the service that they're receiving now, and you're going to need to sell that property. Well, once there's a guardian appointed, there's a whole different process to selling it. It's not that the guardian can just go out, hire a broker, get a contract to sale and move on. They have to petition the court for permission, number one, to sell the real property. Hey, judge, can I sell this real property? The judge is then going to appoint a real estate broker or approve one that is requested in the petition, and their commission is always going to be limited to 4% unless there's special circumstances, and the judge takes it easy on them, gives them a little bit more. So if you do have a real estate broker you want to work with, they need to know right off the bat, you're not going to get 6%. You're not going to get anything over 4%. So that's important to convey to them. And then once you have identified a buyer based off of this real estate broker's actions, you're going to go back to the court and say, hey, court, we have a buyer. This is the contract to sale. And the judge is going to say, great. Now I'm going to appoint a appraiser who's going to go out and make sure that the value of the contract of sale, that the purchase price, is reasonable. And I'm going to require that you publish something in the newspaper to open this up for bidding for the general public. And generally speaking, if the appraisal is within $20,000 or $30,000, depending on the value of the home, the judge is going to say, okay, whatever the purchase price is would be fine. If it's wildly different than what it can get from the appraisal, or if a bidder comes along and outbids the purchase price, then that contract of sale is put to the side, and there's a new buyer in town. But once the contract of sale is approved, then the judge issues an order approving the contract of sale. You go to closing, and then you have to go back and have it approved to have the money taken out of escrow. So sorry for the long story, but long story short, it's a process, and it's not something that's just easily done. So there is that capability of selling the property, but you have to go through the motions. So just two quick case studies. Sally and Leo. I kind of wanted it to be Kate and Leo, but I thought that was too kitschy, so we changed it. Anyway, Sally's 83. She has Alzheimer's, and her daughter is concerned for her mother's well-being. It's a common scenario, happens all the time. Leo is 70. He unfortunately just suffered a massive stroke and is expected to need extensive long-term care services. What do you do? What do we need to think about first? For Sally, as an attorney, what I want to know is, does Sally have advanced directives? Did she execute a durable power of attorney, a healthcare proxy, a living will? If she did, way back when or recently, I want to take a look at them. I'm not going to hear from a client, yeah, my mom's got power of attorney, my mom's got a healthcare proxy, we're good here. Now, where do we go from here? No, I want to look at those documents, make sure that they're executed properly, they're still in full force and effect, that she didn't miss anything. Want to find out what the powers that this agent under power of attorney has, whether there's a backup to the power of attorney, just to make sure we can rely upon them for planning purposes. If there are no advanced directives, then in this case, I think an Article 81 guardianship may be appropriate. I'd want to get a little bit more information about Sally and what her capacity is to see if maybe she could sign advanced directives, because even if somebody has dementia or Alzheimer's disease, maybe they have a lucid moment, maybe they have just enough capacity to execute something and we want to strike while the iron's hot. Probably not, but I'd like to rule it out before we jump the gun and go into a guardianship proceeding. And if you are going to go for a guardianship proceeding, I would suggest that since this is something that's only going to very likely get worse, you request broad authority to handle long-term care planning immediately in that guardianship proceeding. For Leo, he's 7 years old, just suffered a massive stroke, unfortunately. Again, we want to confirm if he has advanced directives, and if no advanced directives are in place, then he may need immediate assistance because it's an emergency situation, and he may be in a hospital, very likely he's in a hospital or a hospital setting, a hospital-like setting, and the Healthcare Decisions Making Act may be able to hold him over for a bit to see where he goes from there. If he's not able to kind of rehab from this massive stroke and he does need assistance, then you're very likely going to need to be going for a mental hygiene law Article 81. 17A is not appropriate in this case. I don't know why that's on the slide, and I apologize. So it's definitely going to be a guardianship 81 if he doesn't have advanced directives, or if he doesn't recuperate to the extent where he could then execute advanced directives. So we have some questions.
Yes, we do have a few questions, and I did put in the chat that if we can't get to all of the questions that, we'll try to address them, but if we can't get to all of them, and I did put the email address that what questions can be sent to, as well as follow-up questions.
Absolutely.
So the first question that came into the chat, thank you very much, Eric, it was very thorough. So this comes from, this was actually an email that was sent to me. What are options for parents whose child has an IQ of 89, but deficient in many everyday activities, has required a one-to-one throughout his education and can't keep on track for more than 10 minutes and wouldn't know what to do in an emergency or even really understand what an emergency is?
Okay.
That's a lot.
Yeah, no, and I digested all of it. That is a common scenario, believe it or not, and it's very challenging for the family and very challenging for the individual, the child. First off, I'm sorry, was it a child who's over the age of 18?
Yes.
Okay. So.
Oh, no, I don't, it's not clear whether or not is over the age of 18, has an IQ of 89.
Okay, so let's just work off the presumption that they're 18 or older, or they're approaching 18 years old, because before then you're their parent, you can make decisions for them in a lot of regards, just as such. But once they're into adulthood, that's a very difficult call, because I don't know that a 17A would be approved in that case. IQ of 89, the court's going to, depending on the judge, depending on what court, they're going to review that and say, no, there's no way that this person needs a guardian. So if there is a guardianship that is on the table, or that conversation is had, I would say it's going to have to be in Article 81. But I would want to take a step back and just assess the situation and see if they have the capacity to execute a durable power of attorney, a healthcare proxy, a living will, and assess what this kid's personality is like, or this person's personality is like, and see if they would be willing to rely upon, trusted people like their parents to help make those decisions, and explain to the parents that, okay, an advanced directive is probably the softest approach, and I would maybe want to consider that first before you jump into a guardianship, for a couple of different reasons. The guardianship, whether you like it or not, brings a stigma, and I don't know that an 18-year-old or a 19-year-old would want that kind of stigma at such a young age if they have such a relatively high IQ for someone in that situation. So I would want to start with considering a durable power of attorney, healthcare proxy, living will, and HIPAA authorization, and have the parent monitor it and make sure that this is something that's working. If it's not working, then we need to go into an Article 81 guardianship. The thing with the advanced directives, especially when you have a young adult, is that they could be revoked. So that's the concern I would have. It's not a quick and easy decision to make those advanced directives. But if somebody gets such a whispering in their ears, you really don't need your parents' help. You can do it on your own. Where they get those thoughts, they may revoke those advanced directives, and then you're left with the Article 81. But I don't think a 17A would work in that case, unfortunately.
Okay, just so in the essence of time, I'm sorry, we're going to move on to the next question. So the second question comes from Christine. What would be the benefit of living will over a MOLST form, the medical order of life sustaining treatment form?
Well, Well, the two different things. I think that the most will provide information with regard to your medical, your life-sustaining treatment. But a living will, if you don't have that, a most is not going to do the trick for removing your life support or preventing life support. It has to be a living will. It's like, to me, the most is the toolbox, and the living will is the tool. So you're going to need the living will.
Okay. Third question, on average, how long does the court process for guardianship take, and is there a way to expedite it?
Good question. So depending on the circumstances, you could, if there's an emergency, you could seek a temporary guardian and request an emergency order. So it could be expedited. In my experience, it's not as quick as you want, even if you're having a real emergency situation, and it's got to be like a life and death situation for the court to actually act. But typically, Article 81, from soup to nuts, from the filing the petition to actually receiving the commission, depending on the county, it could be, 3 months, maybe 4 or 5, depending on the speed at which the court process things. I mean, unfortunately, in some counties, they have more cases, so they're bogged down a little bit more, and it takes longer to get the guardianship underway, even if you've had the hearing. But I would say, just to be safe, 4 to 5 months.
Okay. Another question comes in from Nina. How do you proceed with a person who needs a guardian but doesn't have assets? They have no assets.
So meaning how to pay for the proceeding itself? That's how I'm envisioning that question. So, or interpreting it. So the petitioner will need to cover the cost of the proceeding themselves. Depending on the circumstances, I don't know, you can reach out to Adult Protective Services. Sometimes Adult Protective Services, depending on the case, may petition the court themselves. Or if the person is in a facility, then sometimes the facility will take on that role, just to make sure that they have Medicaid or access, any money that they do have access to, that can cover the cost. But generally speaking, if they don't have resources, the petitioner is going to be bearing the cost of that, unfortunately.
Okay. One last question. How do the courts become aware of the death of a guardian, and what happens if there was no one else able to be the guardian? So how do the courts know that the guardian may have passed away if if there's no one else to tell the courts?
Right.
And then
what happens if the person who's going to be telling them everything? So it's kind of a default. It's if the court examiner doesn't hear from you when you are supposed to have done something, whether you're supposed to file an annual accounting, or if you were supposed to respond to a particular order for something, then they're going to know something's wrong, and they're going to reach out to you and try to investigate where your stuff is. So it's unfortunately a very tough thing to do. There's not like, they don't have like a life lawyer on you or anything. It's going to be a matter of you missing deadlines, and the court examiner is charged with finding out what's going on. And that could take a while. They could just send one email a month or try and leave a voicemail for you, but they'll eventually figure out that something's wrong, and they'll alert the court to it. That's a really good question. It thankfully doesn't happen too often, but that would be the mechanism that alerts the court to your passing.
You would also,
if it's the ward, God, I'm sorry.
I'm saying you probably would, depending on what the guardian was doing with their person, depending on if they were living someplace, a supervised setting or something like that, and if that particular place did not hear from the guardian or anything like that, and they probably, things would go. It would
alert them. Or if there's a backup guardian, a successor, typically that successor guardian has some understanding of what's going on with the guardian, and if they've passed away, then they know that they're stepping into that role. So they're going to have to petition the court and alert the court to the passing of the guardian. It's really a practical question, not like a legal mechanism.
Yeah. These are very good questions. Thank you all. Yeah. Yes, someone's asking if whether or not a copy of the PowerPoint will be available after the webinar. And yes, and as well as the recording, if you want to access the recording and hear it again. Sure. I just want to give you a few minutes just to kind of, finish up if you want to kind of go over a little bit about Russo Law Group. And
sure. So we've been around since 1985. which is longer than some of my clients' kids. And we have 5 partners, 5 associates, and we have 20 plus case managers. So we're an established firm, and we have a couple different convenient locations: Garden City, Lido Beach, Islandia, and we're always available virtually, no matter where you are. And we do more than guardianship. So I'm the partner in charge of the guardianship department, but we also practice estate planning, elder law, special needs planning, real estate, small business, Medicaid planning. And a lot of times these other areas of practice will be needed to help a guardian accomplish certain activities or goals like Medicaid planning or real estate. So please, if you have any needs or know anybody who needs any assistance in any of these areas, please reach out to us. We'd be happy to meet with them and provide our services.
And also, I mean, I think you have a really great newsletter, and if you go onto your website, there's a calendar of, different events and webinars, and I know Russo Law Group does do a lot of, informational webinars like this.
Yes, absolutely.
And they're also very beneficial. And again, it's great to hear the information, and sometimes you need to hear it a couple of times, in order to kind of figure out, okay, which direction do I need to go? And I do need to consult with, with an attorney and so forth. So
my favorite thing is when a client comes in and they know so much about the process and they have excellent questions. They're an informed consumer. And then when I say, well, how'd you get so informed? I looked at your website.
Right.
That makes me happy. So please check out our website. We could be a resource for you and your family, whether it's just reviewing the page of the website, reviewing newsletters, as Dawn mentioned, or attending a webinar. More information is better than less, for sure, in this situation.
Absolutely. Absolutely. Well, I thank you all. I know we have just 1 second. Is there anything else that you want to just cover or not? Otherwise, I'm going to end the meeting because we have to do a yoga session in a few minutes with some of our family members.
Don't miss the yoga. Thank you all for coming in, and please
Thank
email us if you have any questions or concerns. Okay.
Yeah, so it's info@jvrusso.law.com. VJRusso.law. Right. So I did put that in the chat. So if you guys want to take a look, and if not, you can always reach back out to me and I can forward the information. So thank you. Feedback coming back is that thank you very much. It was very informative. Oh, perfect.
Right.
Thank you.
Thank you,
All right,
everybody.
everyone. Thank you so much. And thanks for
nice
signing
day.
on and for your patience, and great presentation, Eric. I really
Thanks a lot.
appreciate it.
Thank you.
All
for
right.
having me,
Take care,
everybody.
everyone.
Bye, guys.